Hi, my name is Marcia Chatelain, and I'm the Penn Presidential Compact Professor of Africana Studies at the University of Pennsylvania. And thank you for joining me today for my class, The 5 Most Important Civil Rights Cases You've Never Heard of. As a historian of African American life and culture, there isn't a more exciting time to explore with my students than the U.S. Civil Rights Movement. Many of us are familiar with moments like this from the 1963 March on Washington, when Martin Luther King Jr. shared his vision and his dream for the nation. But there's so many cases and so many individuals who comprise the civil rights story of the United States that it's important to always take a deeper look, to look at the moments before the 1960s and before the 1950s when people were making history inside and outside America's courtrooms. Thurgood Marshall is considered one of the most important jurists in U.S. history. Born in 1908 in Baltimore, Maryland, Thurgood Marshall rose the ranks of civil rights lawyering to become the first African-American Supreme Court justice in 1967. Many people know of Marshall and his incredible work on the Brown v. Board of Education case, the pivotal moment when the Supreme Court determined that separate and equal were inconsistent with the U.S. Constitution, opening up an opportunity for America's public schools to become integrated and laying the foundation for incredible pieces of legislation like the Civil Rights Act of 1964 and the Voting Rights Act of 1965. But few people realize that Thurgood Marshall had a long lawyering life before the 1950s, and some of his early cases after he graduated from Howard Law School in Washington, D.C. in 1933 and joined the National Association for the Advancement of Colored People, Legal Defense and Educational Fund in 1940 were really a set of experiences that allowed for Marshall to learn about the possibilities as well as grapple with the limits of the U.S. Constitution and American law. And so today I want to talk a little bit about this moment in which African Americans were hopeful that they would see substantive change in their everyday lives as pioneering folks like Jackie Robinson were breaking barriers in other sectors. But the question of civil rights continued to plague all people who are concerned about equality and justice in front of the law. This moment between 1933, when Marshall graduates from law school, and his victory in Brown v. Board in 1954, comprised a series of moments that we sometimes call the Season of Hope. The Season of Hope is this period of time when African Americans are hopeful for what is possible in the second half of the 20th century. We know that in 1933, President Franklin Roosevelt responded to the ravages of the Great Depression with a series of legislations and initiatives called the New Deal that brought the possibility that the federal government could change people's everyday life into stark reality. The New Deal period was a time in which African Americans banded together to try to lobby the federal government to ensure that they weren't left behind in this incredible moment of recovery. So in 1933, the Joint Committee on National Recovery provides an opportunity for African Americans to weigh in on how monies should be spent to get Americans back to work, back to school, and back into believing in the promises of the democracy. In 1940, we see a new wave of African Americans leaving the Deep South to go to northern cities like Detroit, Baltimore, New York City, Chicago, and Los Angeles. And in these cities, African Americans, for the first time, are realizing the power of their vote. And as they become incredible voting blocs in northern cities, they start to reflect about the inequalities that they had escaped in the South. No assessment of the early civil rights movement is complete without acknowledging the incredible impact that World War II had on African Americans who were using military participation and patriotism in the war effort as a way to make a case for their civil rights. The period between 1939 and 1945 sees a wave of new enrollments of African American men and women in the armed services, and this service will become the basis for some of the cases that Marshall will argue in his early career. Between 1941 and 1947, the first March on Washington movement emerges. And this was a movement to try to guarantee that the federal government would include African Americans in new opportunities for federal work tied to the war effort. The March on Washington that we know in 1963 traces its history to the 1940s, when it was seen as a moment in which organized labor and other concerned groups could come together on behalf of African American employment rights. Soon after, major civil rights organizations like the Congress on Racial Equality is established in 1942, and then we have big moments like the integration of Major League Baseball by Jackie Robinson in 1947. The following year, President Harry S. Truman makes the decision by Executive Order 9981 to desegregate the military, expanding the opportunities for African Americans in the armed forces. For African American soldiers to make claims about their right as citizens and as veterans. So in this 20-year period of time that many people have mistaken as inactive or as very as secondary to some of the civil rights victories we see in the 1950s, Thurgood Marshall is learning how to be a civil rights attorney. One of the fascinating things about Marshall's career and the career of his colleagues in civil rights is that a lot of them started out working in courtrooms on cases like public drunkenness, on hit-and-run cases, on cases that didn't have the gravitas of civil rights, but allowed them the opportunity to learn how to argue, how to defend clients, and how to be present as a Black attorney practicing in the United States. These smaller cases would become pivotal in boosting Marshall's confidence and his comfort in courtrooms across the country. So the first season of Hope Case that I want to alert you to is one that was very personal to Thurgood Marshall, and that's the case of Murray versus Pearson, which appears before the courts in 1936. Donald Murray was a 1934 Black graduate of Amherst College, and he applied to the University of Maryland Law School. Marshall was denied admission to that very same law school in 1930 on the basis that African Americans were not admitted to the University of Maryland. This case is one of the many early cases in which we see the integration of public law schools. While many primary and secondary schools were integrated in the 1950s and 60s as a result of Brown v. Board, prior to that, we see the integration of graduate and professional schools because many state institutions could not evade the responsibility of providing graduate education and training to African Americans by simply either paying for their tuition to go to another school, sometimes a private institution in another state, or merely recreating an all-Black equivalent of that graduate school. So in Murray versus Pearson, the denial of Donald Murray on the basis of race is challenged by the idea that a state-funded, tax-driven institution cannot deny one of its state citizens entry to law school. And part of the ruling in the Court of Appeals in Maryland said that the case as we find it then is that the state has undertaken the function of education in the law, but has omitted students of one race for the only adequate provision made for it, and omitted them solely because of their color. If those students are to be offered equal treatment in the performance of the function, they must at present be admitted to the one school provided. If there's only one state law school, then it has to be open to all people. And so this case was incredibly poignant and endearing to Marshall because he understood the experience of denial. He joined many of his colleagues at Howard Law School who had been denied from their state institutions. And here he was arguing on behalf of a fellow Marylander for the opportunity to go to the University of Maryland Law School. The impact of such a case provides an opportunity for us to know that throughout the country, in the North and the South and some locations in the West, other African American graduate students were making arguments based on Murray in order to enter law schools, medical schools, library science schools, and so on and so on. And so this provides the basis for these graduate school cases that not only help dismantle school segregation in the K through 12 area, but what it does also is alert people to the fact that there's a growing body of Black professionals who are going to be educated at very few institutions, but will have an outsized impact in the role that they're going to play in future civil rights cases, in establishing African American hospitals, and contributing to the tradition of historically Black colleges and universities. The next case in 1943, Adams versus United States, is an important case because it involves African American men in the military. The facts of the case are a sexual assault case involving 3 African American soldiers who were on base. One man was accused of the assault of a white woman, and the other 2 men were ordered to escort the victim of the Camp Claiborne premises where the assault was alleged to have occurred. 2 of the soldiers refuted the rape allegation, and all 3 men were ultimately charged with a felony and sentenced to death because the crime and the trial occurred on federal lands. Now, this is a really complicated case, but I want to alert you to a few things that are important to understand. Sexual assault was a capital crime in the South throughout the 1940s and 50s. African American men were usually the ones who were given the death penalty on assault cases. And we also know that during this period of time, even though there is a decrease in the number of lynchings in the South, the practice of assigning death penalty punishments to African Americans on cases that had very slim evidence was a standard occurrence throughout the South. In fact, it was an occurrence like that that brought Rosa Parks one of her first investigations as a secretary at the NAACP in Alabama. And so these cases were really common, and many African Americans, especially members of the NAACP, were concerned about the act of scapegoating or the act of lynching as a response to these allegations. So this case involving Black soldiers becomes an important place for Marshall to advocate on behalf of Black defendants, as well as to make a case about jurisdictional authority in cases that might occur with other African American soldiers. And this case actually went to the U.S. Supreme Court, and they ruled that since the government had not accepted jurisdiction in the manner required by the Act, the federal court had no jurisdiction over the proceeding. It's in this view that it was immaterial that the state of Louisiana authorized the government to take jurisdiction. If the government doesn't take jurisdiction, they can't issue this type of verdict. And this case was one of the many dangerous and one of the many risky cases that Marshall takes on, because as an African American lawyer traveling to the South to represent African Americans, he was often pursued by members of the Klan, of local police. His life was often threatened, and you see the ways in which the lawyering of the civil rights movement, particularly at this time, is an incredibly courageous act to not only stand up for the rights of others, but to also risk violence and perhaps death because of the position you take. And so the implication for this case is that Marshall and other civil rights attorneys would find themselves at the center of these very controversial sexual assault cases that were shaped by racism and a lack of due process, while battling the extralegal and terroristic violence of groups like the KKK. The case that many of you may be more familiar with is the Groveland Boys case, which was the topic of a Pulitzer Prize-winning book, Devil in the Grove, that looks at the arrest of African American Orange Grove workers and the ways that Thurgood Marshall had to drive from New York City down to Florida in order to investigate the case and represent the men. A pivotal case, also during the Season of Hope, is the 1944 case of Smith versus Allwright. And this is a case that comes out of Texas that essentially challenges some of the protocols that were used in state primary races in order to exclude African Americans from voting. If you're familiar with the history of voting rights, you know that there were a series of measures that were used to keep African Americans from voting, from poll taxes to literacy tests to even threats of violence and intimidation as a result of people registering to vote. But in this case, Lonnie Smith, a black voter in Harris County, Texas, sued SS Allwright, the county's election official, because in the Texas Democratic Party system, there was a rule that only white voters could cast a ballot in a state primary. And that meant that the state of Texas allowed political parties to create their own eligibility rules for state primary elections. One can only imagine if there was a system that limited who could vote for a presidential candidate in a primary, all of the potential problems it has for the possibility for democracy to unfold. This case also made it to the Supreme Court in 1944, and they ruled that the right of a citizen of the United States to vote for the nomination of candidates for the U.S. Senate and House of Representatives in a primary, which is an integral part of the election process, is a right that's secured by the federal Constitution, and this right of the citizen may not be abridged by the state on account of his race or color. Now, mind you, it would be another 21 years before the Voting Rights Act of 1965 would put down the final barriers to African American voting. But in the state of Texas, through Smith versus Allwright, at the very least, the possibilities that African Americans can have some say in who ends up on the final ballot becomes an important early step to securing voting rights. And this allows for us to understand a framework that the end of the all-white primary would be part of the mid-century struggle for voting rights, because it created a legal framework to pursue state-level exclusionary practices, encouraged more black voter registration in the South, and fueled more organizing and direct action strategies against the violence, the poll taxes, and the literacy tests that I mentioned, and open up the way for equal access to voting in the 1960s. One of the final cases that I want to talk about is about public accommodations. And this is a phrase that many of us associate with the Civil Rights Act of 1964, which bans discrimination on the basis of protected classes in public accommodations. And we often think about those iconic photographs of young people participating in the sit-in movement, people participating in pray-ins in front of churches, kneel-ins at libraries, and different types of civil disobedience to raise awareness and consciousness about what it means for entire populations to be completely excluded from the marketplace and from public spaces that comprise everyday life. And so part of the battle against segregation in restaurants and at lunch counters were these small cases that often involved transportation, amusement parks, different places in which people of different races could ostensibly gather and where they were separated by law. So in 1944, Irene Morgan boarded a Greyhound bus headed to Baltimore. She was asked to move to the back of the bus to accommodate white passengers, a practice that was very common throughout the South. She refused, and a sheriff was called and attempted to present her with an arrest warrant. Morgan, in an act of defiance, ripped up the warrant and eventually hit the sheriff when he hit her. She was arrested and fined $100. And this is not uncommon. Throughout the history of bus desegregation, going up to the iconic moment of the Montgomery bus boycott, African American women particularly were resistant against the authorities when they tried to integrate buses. In fact, many of my students are surprised to learn that in the example of the Montgomery bus boycott, police officers often shared power with bus drivers. Bus drivers could detain people on buses. They could use violence against passengers for not complying with segregation laws. And so it wasn't just a question of where one sat. It was a question of if you felt safe on public transportation on account of your race. The Supreme Court heard this case in 1946, and they argued that it seems clear to us that seating arrangements for the different races in interstate motor travel requires a single uniform rule to promote and protect national travel. Consequently, we hold the Virginia statute in controversy invalid. And essentially what that means is, based on the Interstate Commerce Clause in the Constitution, the federal government has authority to regulate things that happen across state lines. So for instance, if a couple gets married in Arkansas, that relationship is the same relationship it is in California. If you purchase a good or service in one state, there might be different rules stipulating refunds or contracts, but your property still remains yours when you cross state lines. And so buses became an important place to test the Constitution because of interstate commerce. And many early testers of these bus laws wanted to see if bus companies were consistent in their seating practices and if they really hewed to the Constitution's demands to not create segregation across state lines. And this is important because it allows for the foundation for the cases that would fuel the challenge to prohibition against segregation in interstate travel, known as the Freedom Rides of the 1960s, as well as the massive actions that comprise the Montgomery bus boycott. So before any of these major moments are possible, Morgan versus Virginia leads the way that says that interstate travel cannot be inconsistent as people are moving across state lines. When we think about other cases that allow Thurgood Marshall to be successful and Brown v. Board, there are other incredible moments that I encourage all of you to use your curiosity and learn more about, including Patton versus the state of Mississippi in 1947 that ends the practice of all-white juries, Scipio versus University of Oklahoma in 1948 that talks about the physical separation of black students in a state law school, Rice versus Elmore in 1948 ended another all-white state primary in the state of South Carolina, Shelley versus Kramer, a really well-known case in 1948 that ends the practice of racial covenants in real estate contracts, which would allow for sellers to tell buyers that they are not allowed to sell their homes to people because of their racial background. And then Sweat versus Painter in 1950, which comes 4 years before Brown versus Board of Education, which allows for the integration of the University of Texas Law School. All of these cases comprise an illustrious career that isn't just about one moment and one case that is won, but rather a body of knowledge, a number of moments of curiosity that fuel Thurgood Marshall to become the lawyer and the jurist and really a statesman for civil rights later in his life. Thank you so much for joining me for the 5 most important civil rights cases you've never heard of. And please check out my other classes on curiosityuniversity.com.